Next case that will be argued this morning is Edward Greer versus Pamela Greer. It's case number 18CA011407. Both parties are present with counsel. You will each have 15 minutes to present your argument. Appellant may reserve up to 5 minutes for rebuttal. Just let me know if you are going to reserve time, and I'll keep track of it and try to let you know. No children involved in this, so the only other thing I'd say is we do record and post the argument, so we ask that you argue from the front podium, keep your voice up, and so that we get a good recording. And we've read the briefs and are ready to proceed if you are. So, counsel, 15 minutes.
Thank you. I will like to reserve at least 5 minutes.
I'll let you know when you get to 5 minutes.
Thank you.
And you can make that.
Thank you. May it please the court, my name is Mark Stevenson. I am the attorney for Edward Brent Greer, the appellant. This case pertains to an award, a post hoc review of a motion to show cause and an award, a post hoc review awarding attorney fees by the trial court. The General Assembly gave to the Domestic Relations Court discretion to award reasonable attorney fees pursuant to 3105.73B if the court found it was equitable. We submit that it was not equitable in this case to award attorney fees after a post hoc review because the appellee, Mrs. Greer, did not have clean hands. Mr. Greer, through me, sent her a letter requesting or informing her that a claim existed that she had not paid the property settlement awarded many years before. When she received that letter, the record reflects she threw it in the garbage and she did not respond to the letter. Based upon that conduct, the motion to show cause was filed and her attorney fees were incurred. Additionally, there was no financial need which the court could have considered under 3105.73B on behalf or on the part of Mrs. Greer to award attorney fees to her. She made virtually 3 times the amount of income that Mr. Greer made, who is a disabled individual. Rather than apply equity, the trial court determined in a post hoc review that Mr. Greer's motion to show cause was frivolous and awarded attorney fees to Mrs. Greer. 3105.73B does not speak of frivolous conduct. It speaks of what is equitable. Mr. Greer's motion was not frivolous. Merely proving that a party's factual assertion was incorrect, which is what the appellee will argue, is not sufficient to demonstrate that that party's conduct was frivolous.
Well, remind me, did the court find, I've got the order here, but so I don't have to look for it. Did she also find it was equitable to award attorney's fees and then mention the word frivolous after that finding, or did she just base her finding on frivolous conduct?
I believe she used the word equitable. I don't recall the word frivolous.
Oh, that's what you were just arguing, that she...
It's our position, Your Honor.
Okay.
That is what happened.
I got you. Thank you. Sorry.
That she found that there was no basis in fact or law to file the motion, and thus she awarded the attorney fees. In a review after the motion was dismissed before it was even heard.
Okay, I was confused because I didn't recall her using that word either. So
I don't think she did.
okay, thank you
But
for clearing up the confusion.
But I submit to you that's what she did do in her award of attorney fees. Mr. Greer did not recall ever receiving any of the property settlement from Mrs. Greer. Prior to the filing of that motion, he went to the Lorain County Child Enforcement Agency to obtain records with me to learn whether there was any record of it. The records that were produced reflected a little more than $1,800 of a support award had been given to Mr. Greer. No support, no record of any property settlement was obtained prior to the, or payment thereon prior to the filing of the motion to show cause. And Mrs. Greer was sent a letter alerting her that there was a claim for it. And again, she threw it into the garbage, did not respond, thus causing the filing of the motion. And then even after the filing of the motion, she telephoned me, said she did not have a lawyer, said she had paid the property settlement, and she was asked, it's admitted in the record, to produce any records that she had for it, and she never did produce any records of it. We submit that there is no evidence in the record on appeal.
Well, she was paying, what, $100 for the Bureau support?
She was not paying $100 for the Bureau support she was ordered to, but I'm not aware of any record that shows that she did. There was an entry, a journal entry that she was to pay support in an amount of money prior to 1989. I think it was in the spring of 1989, late winter, early spring. And then that order was amended in the fall, and then it was terminated, but it was support. We submit that it's an abuse of discretion for a court to conclude that because a party did not ultimately prevail, that his or her action must have been unreasonable or without foundation, and an attorney fee should be equitably awarded to the other party. That's not equity. I'd like to reserve the balance of my time for one.
You've got 5 minutes, over 5 minutes, but let me ask you your position on the need to have expert testimony on the issue of reasonableness of attorney's fees. What's your position on that?
My position is that in Lorain County, the court has to make a finding of the reasonableness of the time and the hourly rate. But there has to be some evidence to support that. Unlike Summit County, we do not have a local rule that obviates the need for any testimony in that regard. And my recollection is the trial court cited a local rule to explain its reasoning for overruling the objection that there should not have been any attorney fees awarded because there was no evidence of reasonableness with respect to the time or the hourly rate. None whatsoever.
You'll have your full 5 minutes, sir.
Thank you.
All right, counsel, you'll have 15 minutes now.
Good morning, Your Honors.
Morning.
My name is Wayne Nickel. I represent the appellee, Pamela Greer. I just want to address some of the issues, not by regurgitating my entire brief, but to address some things Attorney Stevenson indicated, and to answer your question, Your Honor. There is no mention of frivolous in the entire entry by both the magistrate nor Judge Glass. In fact, the magistrate ultimately found it equitable to award attorney's fees based upon several things. Number one, that the prior orders were valid. Number two, that the plaintiff did not use due diligence in obtaining records from CSCA to confirm whether or not the funds had been paid. And it says that the defendant made several attempts to resolve this matter without filing a motion in court. There was evidence before the magistrate, before she decided that these fees were reasonable and awarding these fees, that warranted this decision by the magistrate. This isn't a situation where a party did not prevail and as such attorney's fees should be awarded. The history of the case is a motion to show cause was filed against my client saying, court, we want you to find this woman in contempt of court for violating a court order. A signed, sworn affidavit was submitted by the appellant, Mr. Greer, saying, I didn't receive any money 30 years ago. Notwithstanding the laches argument, which we didn't even have to get to because ultimately the motion was dismissed by Mr. Greer. But that doesn't negate the fact that my client had to unnecessarily incur attorney's fees. And that's the basis for the motion that was filed. 3105.73 points to the conduct of the parties. It doesn't require that the parties engage or someone engages in frivolous conduct. It doesn't say that. It says the court may award reasonable attorney's fees based upon the conduct of the parties. Here we have a man who hired an attorney to send a letter asking for money that was already paid. His testimony at the hearing on our motion, not theirs because they dismissed, but the testimony at the hearing on our motion was, I made a mistake, I forgot. If you look at the journal entry, and again, this is a very old case, so if you go on a docket, first thing my client did was, when she hired me, first thing I did, was looked at the docket, and those dockets were very, very simple dockets back then. But the entry that my client provided to me when we met indicated, and this is in the record, that the wage withholding against her was terminated almost, as my brief indicates, it was like 63 or 64 months after the parties were divorced. So she was ordered to pay $100 a month, Your Honor. You were absolutely correct. And it was ordered to be paid through the Bureau of Support. Now, you don't see property settlements. I can tell you as practicing law in this area for the last 15 years. Property settlements are not paid through the, quote, Bureau of Support. But apparently, back then, they did that, and this was a valid order. And my client, that money came out every month, and she paid it, either came out of her wages through her employment, or she paid it. And simple elementary math, 64 months after, 1984, when they were divorced, 64 months later, the wage withholding was terminated. My client was never ordered to pay Mr. Greer's support. Mr. Greer was ordered to pay her child support. So you had two orders going on when the parties were divorced. Mr. Greer was ordered to pay my client child support for the parties minor, I think just one child. And my client was in turn ordered to pay the property settlement through the Bureau of Support. That's in the record, and she paid it. So the conduct that we're suggesting, Your Honors, is the conduct of, after 30 years, conveniently forgetting that you received money that you admitted under oath that you received, subsequent to filing an affidavit saying, I didn't receive it. Moreover, there was evidence presented that Mr. Greer traveled to the Child Support Enforcement Agency and did obtain some records before he filed his motion to show cause, before my client received a letter saying you owe all this money. And the evidence showed that he at least received $1,800, but that's nowhere in his affidavit. When you're owed money and you've received some of it, at least that's what the evidence was at that point perhaps, and I'm not suggesting, but if you're owed money and if you've received evidence that you've received part of it, don't you think you'd maybe disclose that in the affidavit to the court where you're saying you're owed the full amount? He wanted the full amount, and he's already paid it. So, the conduct that we're suggesting that makes the award of attorney's fees equitable is what Mr. Greer, and yes, he apologized at the hearing. He made a mistake, I'm sorry, but that doesn't negate the fact that my client had to unnecessarily hire a lawyer to defend her, because if you're found in contempt, there's penalties that go along with that. There's purge penalties if you truly did know the money, which she did. But if you don't purge that, you could go to jail. So yes, she needed to get a lawyer at that point. And admittedly, she threw the letter in the garbage. There's no dispute on that. My client freely admitted it. But this was 30 years later. She gets a letter saying you owe money. And money that she knew that she paid. Her ex-husband just forgets receiving $6,300. And again, I don't think the conduct needs to be found to be frivolous. It's merely the act of what he did to bring her to court and require her to retain an attorney for those services. Again, the idea that my client somehow has unclean hands is absurd. The blame is being placed on her when she did everything she was supposed to do. When she was divorced, she paid off the money that was supposed to be paid. And then all these years later, she gets a demand that, oh, you didn't pay it. and somehow she's required to produce records from 30 years ago so that Mr. Greer doesn't file a motion to show cause. I suggested this to Judge Glass, and I'll suggest it to you. Where does this stop? Litigants are gonna look at their 20, 30, 40, 50-year-old divorce decrees, conveniently forget that they received money, and then bring people to court. And so I think the court, Your Honor, didn't say it in the decision, maybe they're sending a message that before you ask the court to find someone in contempt, you better have a reasonable basis, and you better put accurate affidavits together that you attach to those motions. So, Your Honor, again, I think what the court did in this matter was completely reasonable. They found that the attorney's fees incurred by my client were equitable. The statements, by the way, submitted indicating what my attorney's fees are, were at the time, were admitted without objection, the invoices from my office. There's no requirement. I understand there's a case that Mr. Stevenson cited in his brief regarding presentation of expert fees. In Lorain County, there is no local rule that requires it. Moreover, I don't believe the statute 3105.73 requires any sort of expert testimony regarding the reasonableness of legal fees in a case such as this. The case Mr. Stevenson cites was a very complex, I believe, commercial litigation case that involved thousands and thousands of dollars of legal fees. This was a case involving just over $1,000 of legal fees. Legal fees, I submit, were equitable to be awarded to my client. If the court doesn't have any other questions, I'll
What about financial need? Is that just another factor the court considers in making that equitable determination?
I think it's a factor that the court can consider, and I think it's separate. But in this case, the amount that was awarded, and the testimony was that I believe Mr. Greer received disability. He made about $23,000 a year. He did get a tax return in the years that the tax returns that were submitted into evidence, and I questioned him about that during the hearing. The court could have, Your Honor, and I'm not certain what they did on the award. I don't think they gave him a purge date, if I recall, because it wasn't a contempt. That's right, it wasn't a contempt. They just said the amount was ordered to be paid. He could have paid it at a rate of $100 a month, just like Mrs. Greer did, all those years ago when she was ordered to pay the property settlement. But I think that's separate. And again, I think the amount that was awarded was not exuberant based upon what Mr. Greer did to bring my client to court, and the fact that of his income level. With that, Your Honor,
I'm just trying to think through the attorney's fees evidence. How was that presented to the court then, without testimony?
there was testimony, Your Honor.
You testified, or?
Well, I didn't testify, but I submitted the statements for the attorney's fees, and they were exhibits that were marked, and my client testified, these are the bills that I've received from your office, and the court, in its finding, indicated, the documents themselves indicated what my hourly rate was and the time spent for the case.
So the court sort of took judicial notice that in this jurisdiction, this hourly rate is reasonable?
Yes, Your Honor, and that's right in the court's decision as well.
Okay, thanks for clearing that up.
Oh.
You had said there's no local rule requiring testimony, and opposing counsel had said there's no local rule dispensing with the requirement of testimony. So therein lies the difference.
Sure.
Is it required in Lorain County outside, even though there's not a local rule requiring it?
Well, Lorain County Domestic Relations Court, I'm not certain what the general division does regarding attorney's fees.
Mm-hmm.
With regard to attorney's fees in domestic relations court, there is no local rule that requires expert testimony to be presented in a request for attorney's fees. And I think that the statute, in and of itself, I mean, this is a relatively new statute, relatively speaking, I think within the last maybe 6 or 8 years. But the conduct of the parties, and all the other factors that are listed, again, there's no requirement in that statute that says.
You're referring to 3105?
3105.73, yes, Your Honor. I think the statute itself kind of lists the factors that the court should consider in deciding whether to award attorney's fees. Thank you very much, Your Honors.
5 minutes.
Thank you. $3105.73 speaks of reasonable attorney fees. There has to be a finding of fact of reasonableness.
Well, counsel, but the judge did do that, right? She did find it was reasonable.
But there is no evidence of that reasonableness in the record.
So you're saying the judge, as the judge for however many years or whatever on the domestic relations court, can't look at an affidavit and review the testimony and what was alleged and say that's reasonable?
I don't recollect any affidavit.
Well, I think he submitted an affidavit.
I don't recollect that he
Oh,
may have.
all right, whatever.
I just don't remember. I think that there has to be some evidence of the reasonableness of the time for the matter that one is asking for attorney fees in the record. Time is one thing, reasonableness, how much time it takes to do this or that is something else. Secondly, that statute's been in effect since 2005, that's 14 years. With respect to the allegation that Mr. Greer admitted that he got the money, he testified very clearly at the hearing that he did not recall receiving any payments from Pamela Greer through the Child Support Enforcement Agency towards the property settlement. Page 46, line 25, page 47, line 8. He didn't recollect it. Now, I was around in the 80s when the domestic relations court was receiving property settlements and payments and dispersing money. Many times in the 80s, there would have been an overpayment of child support to a recipient out of that common fund, and the court on its own would unilaterally enter a journal entry saying, you're going to have to pay this back in some way. You're going to start paying this or that for a certain period of months. I didn't see any evidence in the record on appeal that $100 per month was ever paid on a regular basis by Pamela Greer to Mr. Greer through the Bureau of Support.
I'm sorry.
Go ahead, Kevin.
No, I was just going to say, did counsel, did you object to the fact that the magistrate made a finding that all the property settlements paid? I didn't recall seeing that in your specific objection.
I can't, I don't recollect that, but I don't recollect any record in any evidence in the appeal showing the payments, which is what we had asked Mr. Greer to produce after going to the Child Support Enforcement Agency and learning that a portion of a support award had been paid to Mr. Greer.
And counsel, and I want you to be careful, as I know you will be, in answering this question, to what is in the record on why the motion for contempt was dismissed?
I dismissed it after
What's in the record as to reason?
my statement was, yes, but no evidence as to why.
But there is a statement in our record that says, we are dismissing this motion, and there are reasons given?
I dismissed the motion without prejudice under
Okay.
41A1A. I did not give any reasons.
Okay, that's what.
But yes, I dismissed it with authority from my client after records were given to me a few days before the hearing that I had never seen before.
And that's on the record too, that those records were given to you with payment?
I don't believe that's in the record, Your Honor. I think I made a statement. I don't recall exactly what I said, but I'm not, I did tell the court it was dismissed when we got records, handwritten records we had never seen until just before the hearing on the motion to show cause.
Well,
And we'll be able to see what's in the record. I didn't want to put either counsel in a situation, but it's just a question as to what we're talking about in terms of reasonableness. I'm sorry, go ahead.
no, you covered what I was going to say, so thank you. You've got about 30 seconds.
30 seconds. Mr. Nichols said there were several attempts on the part of the appellee to resolve this. I don't recollect any attempts to resolve this. Had Mr. Nickel obtained those handwritten records before that hearing and sent them to me, I would have sat down with my client and said, we're gonna dismiss, or recommended that we dismiss. There was no effort to resolve this before that. Again, there's no, there is no evidence on the record on appeal to support an equitable award of attorney fees to Mrs. Greer. And we ask that the court reverse that award and enter judgment in favor of Mr. Greer to end this. Thank you.
Thank you both, counsel, for your arguments this morning. The court will take the matter under advisement, issue a decision in due course, and the clerk of courts will mail you both a copy of the decision once it is released. The opinions are also posted on the Supreme Court of Ohio's website, so you can keep your eye out there for the opinion.